Hello, and welcome to the CastlePo e-forum on the amendments to the Professional Misconduct Regulation. As this e-forum is virtual and we are not all gathered in the same space, we recognize that this territory acknowledgement may not represent the lands upon which you are now. If this is the case, we ask that you take the responsibility to appreciate the traditional territory you are currently on. We acknowledge these lands as the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. We acknowledge that Tkaronto, a Mohawk word meaning the land where trees stand in the water, is covered by Treaty 13 with the Mississaugas of the Credit. These lands are now home to many diverse Indigenous peoples and communities. We are thankful to the peoples who have since time immemorial cared for Turtle Island, which includes the land now identified as Ontario. Acknowledging these traditional Indigenous territories is one way for us to recognize the rights and history of Indigenous peoples. It is also a small way for us to work towards dismantling the continued impacts of colonialism. We are all members who share a dish with one spoon, which teaches us to live on these lands with respect, nonviolence, and sustainability. My name is Dana Prucci. I am the Director of Professional Practice and Quality Assurance at CastlePo and a speech-language pathologist. With me is Priya Singh, who is CastlePo's Director of Professional Conduct, General Counsel, and the Diversity, Equity, and Inclusion Officer.
Good afternoon, everyone.
As always, we wanted to welcome you today and also remind you that it might work best for this program if you close anything else that you have open on your computer. If you do experience any technical issues, please exit and then return again. There is a place that you can type in questions. We'll be monitoring the questions throughout the e-forum and we'll try to get to as many of them as possible. If we don't get to your question, then we will respond to you after the e-forum. The recording and the slides from today will be published on the CastlePo website. So let's take a look at our agenda for today. We'll start by looking at the background, the application of the Professional Misconduct Regulation, amendments to the regulation, and then we'll end with putting the misconduct regulation into some scenarios. Background. CastlePo had consultation with registrants and other interested parties, and the board of the college approved the amendments to CastlePo's Professional Misconduct Regulation. In order for regulations to be proclaimed, the amendments must be approved by the Ontario government. Everything was proclaimed, and now the regulation has been posted to eLaws. The proclamation took effect on July 1st, 2024. So provisions are from July 1st, 2024 going forward. For anything taking place before and up to June 30th, 2024, these will be dealt with using the previous version of the Professional Misconduct Regulation.
I'm now going to take you through application of the Professional Misconduct Regulation. Now, most registrants believe that once they're notified of a complaint or an investigation, they assume that they must immediately appear before a panel of discipline committee to respond or address allegations of professional misconduct. This is not true. There is a process that needs to be followed and completed before any findings of misconduct are made, and not every case is referred to discipline. So to understand the Professional Misconduct Regulation, we need to understand that the regulation is setting out actions that audiologists and speech-language pathologists are not permitted to engage in. These are essentially restrictions on practice. They are referred to, generally speaking, as acts of professional misconduct, and they are specific to the practice and professions of audiology and speech-language pathology. Now, there are other acts of professional misconduct contained within the Regulated Health Professions Act, and those acts relate to all regulated health professionals. So, for example, among the 26 health colleges, each college is required to maintain and operate a quality assurance program. All registrants of every college are required to participate and comply with the quality assurance program. A failure to do so makes it an act of professional misconduct, and that is articulated within the RHPA. The amendments that we're going to be discussing today conversely, relate specifically to the conduct of audiologists and speech-language pathologists. Now, only a panel of discipline committee has the authority to make findings of professional misconduct. I can't make those findings. Dana can't make those findings. It is the exclusive jurisdiction of that committee. With every case, a panel of discipline committee is tasked with determining whether a registrant is guilty of professional misconduct based on the case that is presented by the college. The basis for that case is borne out from results from a college investigation, and that investigation starts with the Inquiries, Complaints, and Reports Committee, or what we refer to as the ICRC. The ICRC, in conducting an investigation, either of a complaint or one initiated by the registrar, is tasked with doing so in a fair and unbiased manner. So the purpose of the investigation is not to prove the concerns that have been raised, but rather to collect information that relates to those concerns. Sometimes they do in fact prove the concerns that have been raised, and sometimes they refute them. During the course of the investigation, a registrant has the right to participate in the investigation. And so what that means is not only are they provided with notice, they're given the opportunity to respond to various reports, witness statements, and patient records that may be at issue. At the conclusion of the investigation, the ICRC will determine whether the investigation does in fact support the concerns, and if so, whether those concerns are of such a serious nature that it warrants a referral to the discipline committee in the interest of public protection. What happens, if that is the case, is notice is provided to the registrant that there has been a referral of specified allegations to the discipline committee. Now, it's important to understand here that registrants themselves are not referred to the discipline committee. Rather, specified allegations about their conduct are referred. Specified allegations are essentially a high-level overview of the college's investigation, identifying key pieces of information as they relate to acts of professional misconduct. And in this process, the registrant also has the right to participate in the hearing as well as respond to the college's case. We're now going to turn to some of the amendments. Excuse me. We have a very brief disclaimer. Throughout the presentation, we will use the term member and registrants interchangeably. These terms are synonymous with member, as has been defined in the Regulated Health Professions Act, as well as the Audiology and Speech-Language Pathology Act. There are general amendments across the entire regulation. Specifically, the term client has been removed, and it now only refers to patients. There's now the inclusion of inclusive language, and so you will see she or he has been replaced with they. There's also been some renumbering of the provisions. Now, specifically, paragraph 4.1 is new and states that it is an act of professional misconduct to fail to appropriately supervise a person whom a CASLPO member is professionally obligated to supervise. This new provision captures tasks that are assigned to non-members, such as support personnel, who have not been appropriately supervised. Take, for instance, a CDA who's providing patient assessments. Previously, an allegation of failing to appropriately supervise support personnel would have been captured under paragraph 2 of the misconduct regulation, which says that it is an act of professional misconduct to fail to maintain a standard of practice of the profession. However, this amendment now classifies this particular area's practice as an act of misconduct, as it reflects the serious risk of harm that may result from unsupervised practitioners providing care. The next paragraphs speak to what we like to call holding out provisions. Now, paragraph 4.2 makes it an act of professional misconduct to permit, counsel, or assist a person who is not a member of CASLPO to represent themselves as such. It is also an act of professional misconduct to permit, counsel, or assist a person who is not a member of CASLPO to perform a controlled act if that person is not already authorized to do so. These acts would also violate title protections under the Audiology and Speech-Language Pathology Act in relation to paragraph 4.2, as well as provisions for protecting the controlled acts under the RHPA for paragraph 4.3. And so while these provisions relate specifically to CASLPO registrants, there's also legislation that would create consequences for a non-registrant party who is engaged in title violation or performing a controlled act without authorization to do so.
We know that audiologists have the controlled act of prescribing hearing aids, and it is misconduct for an audiologist to permit, encourage, or support another individual to perform the controlled act if they are not an audiologist or a physician.
Paragraph 6 has been amended, and it is an act of professional misconduct to practice the profession while the CASLPO member's ability to do so is impaired by a condition which the CASLPO member knew or ought to have known would impair their ability to practice. So this amendment is broader than the previous provision, which limited the scope as to impairment caused by a substance. The change now recognizes that a registrant's practice may be impacted by more than substance abuse or dependency. It also recognizes that there are circumstances in which a registrant is aware of a condition that is impacting their ability to practice. However, that registrant has not taken steps to appropriately manage their condition in order to practice safely. Paragraph 8 has been changed and has been refined. Paragraph 8 relates to discontinuation of services and states that it is an act of professional misconduct to discontinue professional services that are needed, unless discontinuation would have been reasonable, taking into consideration the enumerated points. Specifically, reasons for why the registrant continued or discontinued services, the condition of the patient, the availability of alternative services, as well as the opportunity that was given to the patient to arrange for all those alternative services before discontinuation took place. Now, this paragraph relates to discontinuation of services that are needed. It does not relate to services that have been concluded and are no longer required, or for services that may be restricted by an agency. For those of you who are familiar with the previous paragraph 8, the provisions or exceptions have not been lost. So for instance, the previous exception under subparagraph 4, which allowed registrants to discontinue services if there were restrictions of length or type of service that are imposed by an agency, has not been lost, but would now be captioned under section or subparagraph 1, which is the registrant's reasons for discontinuing those services. The amendment reflects real-life circumstances in which audiologists and speech-language pathologists may need to discontinue intervention with a patient. If discontinuation occurs, it is important to document those reasons based on that itemized criteria so that it's clear why the discontinuation occurred and to determine whether it was reasonable under the circumstances. It's also important to identify what alternative services or recommendations were made and how much time the patient was given in order to make alternative arrangements. Paragraph 10 has also been amended, and so it is an act of professional misconduct to fail to advise a patient or their authorized representative to consult with another healthcare professional who is governed by the RHPA when a CASLPO member knows or ought to know the patient has a condition or requires a service that is outside the scope of the CASLPO member's knowledge, skill, or judgment. This amendment has changed the previous obligation from a referral to advice. Audiologists and speech-language pathologists must advise patients or their authorized representative when services are needed that are beyond the scope of the CASLPO registrant. It is now up to the patient or authorized representative to determine whether they wish to seek out those alternative services. You're no longer required to facilitate that referral. However, registrants are not stopped from making that referral if the patient or the authorized representative requests that you do so. Again, like with paragraph 8 and all actions in your practice, it's important to document this advice so that it is clear that the advice was provided. Paragraph 11.1 is new and states that it is an act of professional misconduct to recommend or provide services or treatment to a patient that the CASLPO member knows or ought to know is or will be ineffective, unnecessary, deleterious, inappropriate to meet the needs of the patient. Essentially, what this means is that audiologists and speech-language pathologists must only provide treatment that is needed. to provide unnecessary or deleterious treatment could cause harm to the patient. There may also be financial loss incurred for purchasing services or products that are unnecessary, and there could be broader ramifications to these actions. There may be a general loss in faith in the profession, where the public loses trust in the professions as there is a perception that there are recommendations for unnecessary treatment, especially if those treatments or products are motivated by financial interests. There may also be wider system harms where third-party payers begin to refuse or limit funding because they've seen too much unnecessary treatment being recommended. Paragraph 15 states that it is an act of professional misconduct to fail to provide the college's contact information upon request. While this may seem like a very minor requirement, it is important for patients and the relevant others to have access to Castle Co information and resources. It's important because that may inform their decision in terms of their care. These parties may require Castle Co's telephone number, fax, email, or address, depending on their preferred mode of communication, as well as any communication barriers they may experience. This amendment also speaks to the overall obligation to behave honorably and professionally in all professional relationships. This is a requirement that is also articulated in the college's Code of Ethics. Paragraph 22.2 is new and states that it is an act of professional misconduct to fail to take reasonable steps to make arrangements with a patient or their authorized representative, when requested to do so, to transfer the personal health information of that patient that is in possession of the Castle Co member to another member. While there's a lot in this provision, essentially it is the requirement of registrants to provide personal health information to a new care provider upon request. This is only done should a patient or authorized representative request that a registrant do so. And it's important that registrants transfer this information within a reasonable time frame. Sending personal health information in a timely and effective manner is key to the delivery of healthcare. Delays can cause harm to patients, and so it's important that registrants take this responsibility seriously. In completing these types of transfers, registrants must also comply with confidentiality requirements, and therefore any transfer of information should follow legislation and be transferred in a secure manner. Paragraph 23 has been amended, and so it is an act of professional misconduct to submit or permit the submission of an account or charge for services if the Castle Co member knows or ought to know the account or charge for services is false or misleading. This addresses situations in which an audiologist or speech-language pathologist knows or ought to know that another person is submitting false or misleading accounts for services on their behalf. Registrants are required to understand how their name and credentials are utilized by their company or organization and to ensure that they are being utilized appropriately, especially when billing another party. Explanations of "it wasn't my responsibility," "that wasn't my job," "I didn't know the office was doing that" will not absolve a registrant of their professional obligations to ensure billing under their name is done accurately. Paragraph 25 is new and now makes it an act of professional misconduct to charge a fee or accept payment from a patient or their authorized representative for a service or for part of that service if that service or that part has been paid for or will be paid for by another party. So essentially, this paragraph is specifically prohibiting audiologists and speech-language pathologists from double billing for services. This paragraph also replaces the previous reference to the Ontario Association of Speech-Language Pathologists and Audiologists fee guide, as the college has no control over the fees that are set. These are the provisions that relate to compliance in terms of relationships with the college. Now, as you'll see, there are a number of different paragraphs that relate to different interactions that registrants may have with the college. So, in particular, paragraph 36.1 makes it an act of professional misconduct to fail to comply with an order or direction of a panel of any committee of the college. Paragraph 36.2 makes it an act of professional misconduct to fail to fulfill an undertaking agreed upon between the member and the college, the registrar, or any committee of the college, as well as breaching that agreement. Paragraph 36.3 makes it an act of professional misconduct to fail to provide a reply when requested to a written inquiry from the college within a reasonable time frame. And paragraph 36.4 makes it an act of professional misconduct to fail to take reasonable steps to ensure that any information provided by or on behalf of the CASPO member to the college is accurate. Now, these paragraphs specifically identify the compliance obligations that audiologists and speech language pathologists have to the college. They demonstrate what the expectations are when registrants are engaged with the college or through a process of the college. And it supports governability, because essentially practicing as an audiologist or speech language pathologist is a privilege and not a right. With that privilege, there are now higher expectations and standards of audiologists and speech language pathologists. These provisions are also important to the framework of self-regulation because registrants need to be responsive, accountable, and professional in their conduct, be it with the college, their patients, or associated parties. Now that we've taken the opportunity to cover off at a high level the amendments that have been applied to the regulation, we'd like to open the time up for questions. Feel free to enter any questions you may have in the panel, should appear on your right-hand side, and we'll be monitoring these questions for anything that comes in.
Exactly. So we have some great questions. Thank you so much to everyone who submitted them already. Again, we'll just take a couple questions now and have some time at the end, or we'll get back to you directly afterwards. So we have the first one: if the insurance covers part of the bill for the patient, can we still bill the patient for the remainder? So I would think that would be about. The quick answer is yes, because there's such a thing as copay. So if the session costs $200 and the insurance company covers $100, then you can bill the patient for the last $100. What you cannot do is bill the insurance company for $200 if they cover $200 and bill the patient $200 as well.
Perfect. I also see a question here in relation to specific paragraphs of 19 to 22 of the regulation and whether they apply to hearing instrument practitioners and specialists. The answer is no. The regulations of the college only apply to registrants of the college, and hearing instrument practitioners and specialists are not subject to the college's authority and therefore not subject to the professional misconduct regulations. I also see a question here about double billing. Double billing essentially is a concept or a term that we use when someone has billed for the same services twice. So as Dana indicated, if you are billing for services where only a portion is covered by a third-party payer and the subsequent or remainder of the balance needs to be paid by the client, that would not be considered double billing.
Okay, I'm going to share my screen again. I think we can save the rest of these great questions to the end because we might be covering some of them in the next part.
Great. So we're going to turn to scenarios now, and I have a very brief disclaimer before Dana gets into the first one. These scenarios are hypothetical, so they are based on various made-up circumstances that we have crafted for the purposes of demonstrating how acts of professional misconduct are borne out in practice settings. So you won't see an overview of a discipline matter. What you're going to see are various facts and pieces of information that demonstrate how acts of misconduct may appear in practice. As noted earlier, the ICRC, that investigative committee, will screen all cases to determine whether referral of specified allegation is warranted. And so these allegations will be based on the details that are revealed through the investigation. And so these scenarios set out events and actions that registrants may have engaged in that could result in a referral. So a lot of qualifiers there. So I'll leave it with you, Dana, to start.
Great, thank you so much. For scenario one, Arjun is a speech pathologist who runs his own private practice. Arjun's practice has been very successful, and he has recently hired Sarah as support personnel to meet the needs of his growing caseload. Arjun has worked with Sarah for a few weeks and has received extremely positive feedback from patients and families. Arjun knows that Sarah has recently applied for registration with Castlepoe to be a speech pathologist in Ontario. Sarah was previously registered with the college. However, Sarah told Arjun that because of personal family circumstances, she made the difficult decision to resign. But now she's very excited to return to practice as an SLP. Late Friday afternoon, Arjun overhears Sarah introduce herself as a speech pathologist to a waiting patient. Arjun is surprised by Sarah's introduction and decides to talk about it with her after the patient leaves. Sarah tells Arjun that her registration with Castlepoe is almost complete, and she feels that it's okay to introduce herself as an SLP because she has been one in the past. So I'm going to open our first poll. Here we go. And so there's more than one answer that you can select. There's a few right answers in here. So what should Arjun do? Nothing. Sarah will be an SLP again soon. Terminate Sarah's contract immediately. Inform Sarah that she cannot hold herself out as an SLP until she's registered with the college. Suggest that Sarah contact the patient to explain that she's not an SLP, or leave a note on the patient's file to discuss the matter at the next appointment. Give you a few more seconds to get your votes in. All right, I will close the voting now. As always, thank you so much to everyone who voted. So let's see our results. So we have lots of people that have selected C. Everybody selected C, mostly. We have many answers for D, a few for E, and one for terminate Sarah's contract. So let me close this, and Priya can share the answers that we had.
Perfect. And while I appreciate the nature or the immediacy of terminating Sarah's contract immediately, it may not be required under the circumstances. So what Arjun should do in the circumstances is to inform Sarah that she cannot hold herself out as an SLP until registered with Castlepoe. Almost registered is not registered. The title SLP, as we talked about earlier, is protected by law and can only be used in Ontario by Castlepoe registrants registered to practice in that class. Sarah should also potentially contact the patient to explain that she is not an SLP, or Arjun can leave a note on the patient's file to discuss the matter at the next appointment. Now, while there should be consent on file to confirm that the patient did in fact agree to receive services from Sarah as support personnel, the patient also has a right to know that Sarah is not an SLP given the information that occurred. And so either Sarah or Arjun can take responsibility for correcting the information, or they can both do it. There's really no wrong answer in that circumstance. It's also important to note if a note is left on the file, that's not a part of the treatment record per se. It's really just a conversation that you want to have with the patient. Now remember that paragraph 4.2, it is an act of professional misconduct to permit, counsel, or assist a person who is not a member of Castlepoe to represent themselves as such. Simply ignoring the matter may be considered permitting someone to hold themselves out as a Castlepoe member when they are not in fact registered. And if the patient is not informed, they may feel upset, they may feel duped, they may feel misled, and could then choose to file a complaint against Arjun. And this is where that ICRC investigation would occur. There's also provisions within the, oh, sorry, could you go back? Sorry. There's also provisions within the Audiology and Speech Language Pathology Act that specifically set out protections for the title. We talk about protections a lot. And in this provision, it states that no person shall hold themselves out as an audiologist, speech language pathologist, speech therapist, or use any variation, abbreviation, or equivalent in another language of those particular titles. Therefore, in this scenario, Sarah is in fact holding herself out and could be considered in violation of the Audiology and Speech Language Pathology Act.
We would probably also want to remind Arjun and Sarah of the standard on the use of restricted titles that was passed last year. It's a great document that really explains things very clearly to people that are, well, to everybody, to registrants and people that are almost registrants. Okay, scenario 2. Eileen is a speech pathologist who is meeting with Diego, who is 6 years old, for the first time. Diego has difficulty with specific sounds, like he says wed for red and yamp for limp. Eileen has reviewed the background information and knows that Diego had a complete hearing assessment with an audiologist and there was no hearing loss detected. And Diego was also assessed by the school board speech pathologist who recommended speech language therapy. Sophia, who is Diego's parent, is concerned about Eileen's behavior as she appears confused and is repeating herself frequently. At the end of the assessment, Eileen recommends that Diego work on his L sound by lying down on the floor to practice. Eileen says Diego does not need direct therapy, but should get his hearing tested again, and an FM hearing system would really help him hear the sounds more clearly. Sophia is confused by Eileen's recommendations because the school speech pathologist made different recommendations. When Sophia tried to explain this to Eileen, Eileen becomes agitated and states that she is required to follow Castle Post standards of practice. Sophia asks for the college's contact information to learn about these practice standards. Eileen refuses and tells Sophia that she can just look it up online. A day later, Eileen contacts Sophia to apologize for her behavior. She says that she's struggling with fatigue and remembering details following a concussion that was diagnosed. She invites Sophia and Diego to return to the clinic next week to try again. So it is time for our second poll. Again, more than one right answer. So do you think, what are the areas of concern that you can identify with Eileen's behavior? Is she failing to meet the standards of practice? Is she refusing to provide the college's contact information? Is she practicing as an SLP while her ability is impaired because of the concussion? Is she failing to review the prior assessment information, or is she offering unnecessary treatment recommendations? We're getting lots of votes in. I hate to end this one early. Okay, I'm going to stop the voting now. And this is actually very interesting. We have votes for everything. It looks like B and C are the most popular, with A failing to meet the standards of practice and E offering unnecessary treatment recommendations coming in as well. And of course, some votes for D. So Priya, you can take us through the answer.
Great. Okay. And I appreciate the comments around failing to meet the standards of practice, because I think there are some raised eyebrows in terms of the recommendations that Eileen has made. For the purposes of this scenario, we're going to focus on refusing to provide the college's contact information, practicing while Eileen's ability is impaired by post-concussion scenario or circumstances, as well as offering or making recommendations for unnecessary treatment. Now, as we discussed earlier, under paragraph 6, it is an act of professional misconduct to practice the profession while the member's ability to do so is impaired by a condition which the member knew or ought to have known would impair their ability to practice. So from the details that we have, we know that Eileen has been diagnosed with a concussion. And so in those circumstances, she knew or ought to have known there could be an impairment on her ability to practice. It would have been important in this circumstance for Eileen to seek out help and undertake proactive steps that could have prevented the situation in which Eileen is clearly impaired in her practice with Diego. Further, paragraph 15 makes it an act of professional misconduct to fail to provide the college's contact information on request. Eileen clearly made or denied this information when requested to do so. Paragraph 11.1 also makes it an act of professional misconduct to recommend unnecessary treatment. This provision places a clear responsibility on all registrants to only recommend treatment that is necessary for patients. For example, patient or treatment plans should never be geared towards funding or availability of funding. Treatment must be patient-centered, it must be based on those principles, and it must be done in the patient's best interests.
And some notes on her recommendations, which probably are why people selected A about standards of practice. We know that Diego has perfect hearing. The FM system is expensive and it will not help his pronunciation. It's not that he can't hear how the sound is made. L is a front of the mouth sound, so lying on his back won't help. And at 6 years old, it appears that Diego would benefit from intervention. So on to scenario 3. Leo is an audiologist who receives a notice of complaint from the college. The complaint is from a former patient who is difficult to work with, rude to staff, and has left an outstanding balance on their account. Leo feels that this complaint is a waste of time, as they've been in practice for over 10 years and have never had a complaint before. Leo is asked to respond to CastlePo's notice within 30 days. Leo then forgets about the complaint and does not provide a written response. CastlePo staff follow up with Leo to request that they provide a written response and provide a copy of the patient record. Leo is busy opening a second clinic and asks the administrative staff to draft the response instead. A few days later, Leo finds a draft response on their desk and a patient record attached. Leo expects that their staff has done a good job and sends in the submission to CastlePo without reviewing the comments or the patient record. CastlePo staff contact Leo after receiving their comments because it states Leo has never met the complainant and the wrong patient record has been provided. So let us open another poll and we can think about which of Leo's actions could be considered professional misconduct. Are they failing to cooperate with an investigator or failing to respond to the college when requested to do so? Are they failing to ensure that information provided to the college is accurate? Are they failing to comply with an order of a committee or breaching patient confidentiality? And it's lovely to see all of these votes coming in. Thank you so much. Okay, I'm going to close the poll and share the results. So it looks again like all the answers have some selections, but definitely B, C, and E are the front runners here. And Priya, over to you to take us through the answer.
Fantastic. So I will say, and I will admit, option A was a little bit of a trick because there is no appointed investigator. But again, I do appreciate why that answer would be selected. In this circumstance, it would appear that Leo may have engaged in active professional misconduct in that they fail to respond to the college when requested to do so, failed to ensure that the information that was provided to the college was accurate, and breached patient confidentiality. Now, in particular, paragraph 36.3 requires Leo to reply to the college within a reasonable amount of time when requested to do so. Further, paragraph 36.4 also requires that Leo must undertake reasonable steps to ensure the accuracy of the information provided. As we've seen from the scenario, Leo has apparently failed to meet these requirements. It's important to note in this circumstance that not every case that could constitute professional misconduct will be referred for a formal hearing. A panel of the ICRC will take into consideration all the circumstances of the case, both mitigating and aggravating factors. And so there may be significant mitigating factors that explain Leo's behavior that at this point we are not aware of. And so it's up to the ICRC panel to determine whether that referral is needed in the interest of public protection. Now, in the scenario, you will also see that Leo provided the patient record of a patient who's not involved in the complaint, and therefore their confidentiality would have been breached. If Leo had provided the patient record of the complainant, Leo could do that under the legislation and does not require the consent of the patient to do so. In doing this, the correct record, Leo would also not run afoul of paragraph 12. You'll also see, for those of you who are familiar with the previous version of the regulation, paragraph 12 no longer makes reference to client and now only makes reference to patient as per the amendments.
Okay, here is our last scenario. In this one, Billy has multiple special needs and requires speech language therapy. Sue, his mother, is unable to access private therapy. Billy has been assigned to a school board speech pathologist, John, after being on the wait list for a year. Billy's speech has been improving with this intervention. During the therapy block, Sue asks John on 3 separate occasions for exercises to do with Billy at home. John finds Sue's requests demanding and discontinues Billy's therapy immediately. No arrangement was made to continue therapy with an alternate provider, and John does not document the reasons for the discontinuation. So here is our last poll, and this time you can only choose one answer. Can John's decision to discontinue Billy's therapy be considered an act of professional misconduct? Yes, no, or maybe? Okay, I'm going to close the voting, and we can share the results. So there's a little bit of everything here, but definitely yes is in the majority, with a few people who aren't so sure. 11% say maybe, and 3% say no. So Priya, I will leave it to you to go over the answer.
I'll take it away. So in these circumstances, based on the facts that we know at this point, John's actions may be considered an act of professional misconduct. In particular, we should consider the criteria that's listed under paragraph 8 to evaluate whether the decision of John was reasonable in the circumstances. So first, what were John's reasons for discontinuing services? Based on the scenario, it was Sue's request. However, Sue's request in this scenario would have been reasonable to support Billy's therapy. The second item to consider is around the condition of Billy. And we know from the details that we have that Billy's condition has not been adequately addressed. The last thing to consider in this scenario is whether there was an opportunity given to arrange for alternative services before discontinuation took place. Based on the information we have and the hypothetical record of John, we know that there is no indication that John had a conversation with Sue or provided any information to arrange for alternative services before discontinuation took place. And again, I want to stress in this scenario that there is a difference between discharge or completing a block or allotment of services, which is reasonable and acceptable. This provision relates to discontinuation of treatment that is currently needed.
Okay, so this takes us to the end of our scenarios, and now we have time. We've got lots of great questions in here. Hopefully some of the ones that were sent in earlier have been answered through the scenarios. So let me stop sharing my screen, and we can start going through these.
Okay, sorry, bear with me 2 seconds here. My screen is not cooperating with me. There we go. So there are a couple of comments I just want to make, and I hope that they answer some of the questions. In terms of double billing, there was a request for an example. So say, for instance, Dana as an SLP is providing me with speech therapy. I am working on pronunciations of my R's. She bills me. She also finds out that I have coverage through my third-party payer, has access to that, also sends a bill over to my third-party payer, even though she's already billed me. So in effect, she's billed twice for services that were only rendered once. And that, in a nutshell, is essentially what double billing is. There was a question around controlled acts for SLPs. Currently, under the legislation, SLPs do not have access to controlled acts contained within the Regulated Health Professions Act. And as we know, audiologists have the access to the controlled act of prescribing a hearing aid or device. There was a question around timely manner, and we've mentioned, I'm very guilty of mentioning timely manner and what is reasonable around many of the provisions. Usually this depends on circumstances. And so there is some flexibility within the legislation to take into consideration what may be aggravating or mitigating factors around what's reasonable or what is timely. in cases where there is a concern that the registrant has not responded in a timely manner or has not behaved or conducted themselves in a reasonable way, the college will seek out an expert opinion of another registrant who is experienced and practices in the same area to provide an example or explain what would be reasonable or what would be timely in those circumstances.
Exactly, and reasonable time really can depend on the work setting and the work that you do. I understand that SLPs in hospitals, for instance, everything needs to be documented that day. If we're talking about swallowing, those are things that are very, very important, high risk of harm to the patient. It can't wait. Everything needs to be documented the same day. Whereas in preschool speech and language program, for instance, the PSLs, it might be that you have a week to write your report. In private practice, sometimes there's 2 weeks to write the report. So there's no set answer that CASLPO gives that this is when your records and your reports have to be done. It depends on the work setting.
Perfect. There's a question around complaints that may be lodged that are spurious, really without appropriate intent. There are provisions within the RHPA that will allow a panel of the ICRC to determine that a complaint is frivolous, vexatious, moot, or otherwise an abusive process. It is a fairly high bar that does require written decision that is still reviewable by a third-party body, the Health Professions Appeal and Review Board. But that requirement really needs to be in relation to a complaint where on the face of the complaint, it's very clear that there's no regulatory response that's required. So again, for instance, my treatment relationship with Dana has gone south, and I lodge a complaint because I don't like her hair. Really isn't anything the college can do about that. However, because I live in the world of exceptions, if Dana perhaps has shaved something wildly offensive on the side of her hair, and I now have a photo of that hairstyle, perhaps that does require a regulatory response. So all cases are screened and they're determined whether they meet the requirements to deem something frivolous and vexatious. And if there is a regulatory response that appears to be required and may need investigation to determine whether that response is needed, then the college will continue with the investigation and that complaint will be processed.
We have a question. Once a member resigns, do they have to write their CETP if they want to register again with CASLPO? Yes. So that was something that we didn't talk about in the scenario where Sarah wants to join CASLPO again. But if someone resigns from CASLPO and stops practicing or whatever they do, they would need to write the exam. It's not just that they apply and they're back in and everything starts from the beginning. Resignation is a very big decision, and if it's something that you're considering, definitely speak with registration or with a practice advisor.
There's a question around violation of advertising. And so this presentation today only covered significant amendments that were applied to the professional misconduct regulations that took effect on July 1st. There are 36, excuse me, there are 37 acts of professional misconduct contained within the regulated, or sorry, not the Regulated Health Professions Act, the Professional Misconduct Regulation. Sorry, I'm losing my voice here. There are 36, I'm not going to be able to do this. There are 36 specific acts that can constitute professional misconduct. We only covered the ones that are amended. And so there are provisions within the regulation that speak to title violations or advertising violations that are then supported by the advertising standards. So I encourage you to take a look at the professional misconduct regulations in their entirety to get an understanding of all the provisions that relate to the practice of audiology and speech language pathology. The 37th head of misconduct or act of misconduct relates to what we call kind of a basket clause, and it is in relation to acts that would be considered disgraceful, dishonorable, or unprofessional. So it's a very wide provision that kind of relates to everything else that could go wrong that hasn't already been captured in the preceding 36 paragraphs. So I hope that answers the question, minus my frog in the throat. I see a question around scenario 1. If Sarah continues to introduce herself as an SLP, after the matter has been discussed with her. So it depends on the circumstances. As Sarah has applied, her application may go then to the registration committee, who will evaluate Sarah on a number of criteria, including good character. And so this instance, or the continued behavior of holding herself out despite being informed not to do so, may impact her ability to be re-registered with the college. If Sarah does not obtain registration with the college and therefore does not get access to hold herself out as an SLP, but continues to do so, the college does also have the authority to seek an injunction against Sarah to stop her from holding herself out to the public in a way that contravenes the Audiology and Speech Language Pathology Act.
Great, I think I can take one and give your voice a break. Students are being hired and used as CDAs or SLP assistants while they wait for their CASAPO certification. Is this allowed? Yes, it's actually a lovely idea for SLPs who are not yet SLPs, so SLP students, to gain more experience. However, they have to be very clear that they are not speech pathologists, and as such, they can only take on the actions that are appropriate for support personnel. They cannot perform assessments, they can do screenings, they need to be supervised. They have to sign their records properly and appropriately. All of the things that students or support personnel can do versus what audiologists and speech pathologists can do.
Okay, we also have a question here around a CDA, or a communicative disorders assistant, using the title therapist, maybe not specifically speech therapist, but therapist in the course of practicing. Again, depending on the circumstances, it may be considered a variation or abbreviation of speech therapist, and therefore a violation of the protected title provisions. Again, depending on the circumstances, the college may seek an injunction to stop the person from continuing to hold themselves out as such. And there's also a question around whether the scenarios are based on real situations. They are not. They are fictitious and really created for educational purposes today, but we did not make them fanciful. So I can say that in my experience working in the conduct department, there are cases that have these types of factors that come into play. Little bit more complicated than we presented them here today. And if you are interested in learning more about various cases that would have gone through the ICRC and resulted in a referral to discipline, you can review the discipline decisions that are available on the college's website, as well as attend any hearings that are upcoming. The college's website also lists links to access that, and they can be viewed virtually.
I see there's some more follow-up to having a student or someone who's graduated from audiology or speech pathology program without yet being registered with the college. What are the titles they can use? Again, I would direct you to the standards on use of restricted titles. It really explains, I think, clearly what titles can and can't be used, what designations are appropriate based on someone's regulatory status.
There are some questions around changing the language in relation to patient and client. My understanding is the Ministry of Health is trying to streamline or create consistency among the various legislation that relates to all 26 health colleges. And so I believe it is an attempt to create some sort of consistency in language. For those of you who use client as opposed to patient, that's still fine and it's still acceptable. As we've noted today, we use registrant and member interchangeably, as long as your records and documentation is clear. So myself being client or patient of Dana, the SLP, as long as that documentation is clear, there really isn't a concern or problem between using those particular pieces of terminology.
Most of the documentation that the college puts out now, like the practice standards, FAQs, practice advice, will be using the terms registrant and patient as opposed to client and member, but it's always with that caveat that they are somewhat interchangeable.
There's a question here around how involved do registrants need to be in the billing process. There are many organizations in which the registrant, the SLP, or the audiologist is not directly responsible for billing. Registrants are responsible to know how billing is happening, and if their name or their registration number is appearing on invoices, it's a good idea to conduct an audit to make sure that the billing is being undertaken correctly and appropriately. And you should also have a conversation with the employer or the billing staff or the admin staff to get an understanding of how that billing process works. We understand that sometimes there are mistakes and errors that could occur. And so the regulation is not speaking to mistakes or an accident, accidentally billing the wrong patient, for instance, or your name appearing on the wrong invoice. The regulation is really speaking to where there's a consistent pattern of inappropriate billing, where a registrant who is not involved in the care of a patient has their name applied to those invoices. And that's also a conversation that registrants should have with their employers to ensure those types of practices are not in fact happening. And while that may not be documented in the patient record, we encourage you to keep records of those conversations to ensure that if there's ever a concern that comes up, you're able to demonstrate that you took professional and ethical choices and had those conversations in order to address any billing concerns that you may have had in your practice setting.
And we see this also in quality assurance and peer assessments. People who work for larger companies say they have no say in what is on the receipt. But according to the records regulation, there are 7 specific things that need to be on financial records. And so, for instance, is your name as a registrant on the receipt that the patient gets, or is it just a description of services? And if it's not on the receipt, then you need to make sure that it's there in some way. You can always speak to a practice advisor. We're happy to talk about it. There's a Did You Know that came out in the last couple of years that talks about it. And it's sort of the same thing about advertising also. If you work in a large company, you might say, well, I have nothing to do with the website. I have nothing to do with the advertising. That's all marketing. However, you're an audiologist or a speech pathologist that works for the company. And so that advertising and that website represent you. And so you need to do the ethical thing, the professional thing, just as Priya was saying, and make sure that it is appropriate and that it follows the standards.
I also see a question here around composition of an ICRC panel. So the composition of all the college's committees are available on the college's website. They are made up of board members or from the board of directors of the college, as well as non-board members who have been appointed by the board. Depending on the case and depending on the timing of year, we have a standing audiology panel for audiology cases. We have a speech language pathology panel for speech language pathology cases. We are required by law to have at least 3 members of the ICRC sit on any case to make a determination. So it will not be one person. And of those 3 members, 1 person must be a public member. So it does depend on scheduling and timing in the year as to who may sit on a particular case at any given time, but there are certain legal requirements that we must meet in order for the ICRC panel to render a decision.
Okay, I think we're coming to the end of our time. Maybe we'll each take one more question. I have one that came up quite a bit ago. Thank you for your patience. In paragraph 22.2, transfer of personal health information. Does this take into account agency or hospital policies for request of personal health information? Our hospital policy indicates that patients have to go through the health records to request this. So absolutely, it depends on what system you're working in, but you as a regulated health professional need to ensure that the patient knows how to access these records and how to get them sent to the next person. In some places, you, the regulated health professional, would be the one that would be responsible for transferring the personal health information. So again, in practice advice, we're very happy to talk about it. Just to make sure that it does meet all of the standards and regulations. But if there's another step in the process, you just need to help ease the patient on their way, as opposed to doing what Eileen did, which is just, well, you can figure it out for yourself.
And I'm going to take a discontinuation question. So there's been a couple of questions around discontinuation. So I'm hoping that my answer covers more than one question. So discontinuation of services without any explanation, reason, or rationale can be considered an act of professional conduct. If discontinuation of services occurs for the enumerated reasons, so there's a reasonable reason as to why the registrant has done that. The severity of the patient's condition, whether there are alternative services, and whether there was opportunity to get those alternative services. So all those factors would be considered to evaluate whether the discontinuation of services was reasonable. If it was acceptable under the circumstances, then it wouldn't be considered an act of professional misconduct. So those 4 items essentially qualify when discontinuation of services would be acceptable or permitted. It's when there's an absence of those qualifiers occur, that is when it's considered an act of professional misconduct. So there's lots of questions. We will try to get back to those of you who we weren't able to answer today. You may have more questions as you think about what we've said, as you take a look at the professional misconduct regulation, or you look back at the e-forum today or the slides. So if you do have anything, please contact Practice Advice. I am volunteering Dana and her team, who are wonderful and lovely and happy to answer any questions that you may have. The contact information is available on the slide deck. It's also available on our website in case the slide deck is not available and you do have a burning question that you'd like to ask. And we'd also like to thank you today for attending. Professional misconduct regulation is extremely important in terms of the governability and protection of the public. And so very happy to see the responses and the questions and a really engaged profession. Please feel free to connect with us on Facebook as well as YouTube, and visit the college's website for any additional information you may need. Thank you very much again, and have a wonderful afternoon.